Before married couples meet with their estate planning attorney, they must discuss these 9 things between each other, and you're about to find out what they are right now. Hey guys, Elliott Feldman here, estate planning attorney at the Elliott Feldman Law Group, where we create estate plans that actually work when your loved ones need it most. If you ever have any questions about this topic or need to talk about your estate planning needs, you can schedule a time to talk with me over the phone for free by going to myestatemeeting.com. It's different and everyone's circumstances are different. But there are some common things that will come up virtually for every married couple as part of their estate planning conversation. So if you briefly discuss these things beforehand between each other, then you won't be surprised when the estate planning attorney asks you about them in the meeting. You won't be having to make quick decisions because you've already thought about what you might like to do, and that'll make you more confident in your meeting with the estate planning attorney and make the whole conversation just much more efficient overall. Plus, it'll give you the opportunity to have better questions for your estate planning attorney just in case you get stuck on a topic. So why don't we jump right into it? Number 1, what should happen when one of us passes away? So this conversation might go like, you know, honey, do we want to have it where when one of us dies, we just leave 100% of control over our assets to the surviving spouse? Or do we want to have some protections in place for the kids to make sure that they will get our assets at some point after we die? You know, and one of you might say, you know, what worries me is if, you know, I die and leave everything to you, you get married again, or someone in your older age is able to successfully influence you, our kids may wind up with nothing or getting cut out of their inheritance entirely. So maybe we should put some things in place, like when one of us dies, that the spouse's estate goes into a trust for the surviving spouse to use for the rest of their lifetime, and then when the surviving spouse dies, things revert back to the kids. Number 2, after we both pass away, should we give everything equally to the kids? Look, by far the most common answer is that we want things to go to our children equally, but there's also some other situations where people want to provide things for their grandchildren, or people want to make specific gifts of specific assets to a particular child for sentimental reasons, or one of your children is financially worse off than the other, so you want to leave them more money than the other kids, right? So, you know, every situation is different, but the most common answer is that most people want to leave things equally amongst the kids. Number 3, are you comfortable just leaving your assets to your kids outright after you pass away, or do you want to limit their access to their inheritance in a trust? So that conversation might go like, honey, is it okay if we just leave everything to the kids in a will so that they can do whatever they want to do with their inheritance immediately after we die? Or should we leave things to our kids in a trust so that they don't have the ability to blow it all too fast? Or maybe we can help protect their inheritance from any future divorces they might have. Number 4, who is actually going to make sure our estate plan gets carried out when we pass away? So that conversation might sound like, honey, look, when we pass away, we're going to have to designate someone to make sure that everything goes exactly how we have it spelled out in our estate plan. I mean, whether we call that person or persons, executor or trustee, I mean, either way, look, I mean, some couples will say, like, look, why don't we just give it to Mike? Because Mike's responsible, he's good with finances, he has good relationships with the other kids, so he's the obvious choice. And some couples may say, you know what, I don't want all the kids thinking that we like Mike more than them, so why don't we just have all the kids take on that role collectively together as the executors or trustees or co-trustees in that example. Again, if you don't have an answer right away, that's okay. You can bring it up to your estate planning attorney, but these are the things that you want to be thinking about. Number 5, what do we do with all of our personal belongings? Now, we're talking about non-titled personal effects like jewelry, apparel, books, artwork, etc. You know, not super valuable stuff, but very sentimental things to you. And you'll probably come up with one of 3 answers as to what to do with your personal effects after you're both gone. And first option, you know, you have your estate plan instruct your kids to disperse of your personal effects as they would see fit and just let your kids figure it out. Your second option is to include a non-binding side letter in your estate plan that tells your kids, hey, kids, legally our estate plan will let you divvy up our personal effects as you see fit. fit, but if you read this letter, you'll see that we really wish that you would give these certain items to so-and-so because of this reason and give these other items to so-and-so because of that reason. Your third option, look, we better designate in our estate plan that these specific personal items go to a very particular person because we don't want there to be any question whatsoever or any arguments amongst the kids. So let's just put that disposition of that particular personal effect in our legal documents. Now note, up to this point, we've been discussing the conversations married couples should have about what should happen after they die. But now let's talk about what you should discuss when you're alive but you're mentally incapacitated. Number 6, who should handle all of our money if we're both in a condition where we can't make our own financial decisions and sign our names to make financial transactions? Or who should handle our money when one of us dies and the surviving spouse does not have the mental capacity to handle all of our financial transactions and our accounts? You see, that person is called the financial power of attorney. So who do we want to handle that? Number 7, who should be able to make healthcare decisions on our behalf if we are in a surgery or if we can't talk to our doctors or if we have dementia and can't make medical decisions on our behalf? See, that person is called the healthcare power of attorney. So who do we want to handle that? Now, for most married couples, they'll name their spouse to be their financial and healthcare power of attorney, and maybe they'll have a backup successor power of attorney just in case their spouse is not able to assume the power of attorney role at that time. You know, when the time comes, you know, maybe that successor might be the responsible uncle or aunt, or maybe your sister or brother, someone that you know, hold in high regard. You know them to be responsible, and again, your attorney will be able to help you out making the correct decision about who should be taking that role, just in case you or your spouse can't. Number 8, how do you feel about a living will where we state our wishes to have the plug pulled, God forbid, if we're on life support machines? I mean, honey, if we're vegetables on life support with no chance of recovery, do we want to have our kids take on the burden of having to make the decision to terminate our lives? Or do we just want to tell the doctors in plain English and writing in a living will, hey, you know, if we're truly vegetables, then we want you to pull the plug, doc, and take that burden off the kids. Do we want to do that? Number 9, do we want to leave things to each other and our kids in a way that the surviving spouse and the kids don't have to go through probate court when we die? So that conversation might go like, you know, honey, I've done some research online, watched a lot of this attorney Elliott Feldman's video content on estate planning, and it seems if we die and keep everything in our name and we leave everything in the traditional way to each other and to our kids through a will, then there's going to be 2 probate proceedings, one for each of us when we die. And that means our assets are going to be frozen, and our survivors, the kids, are going to have to hire a probate lawyer to go through this court process and have judges order that the assets be transferred out of our names and into their names as the kids. And honey, that process can take anywhere from 6 to 12 months in Ohio and cost up to $10,000 or even $15,000 in attorney's fees at times. But honey, I've heard of this concept where we can create a revocable living trust where we can retitle assets out of our name and into the name of our trust so that when we die, our kids don't have to go through probate, and that way the money that we save on, you know, the kids having to pay for these probate attorneys, they can keep in their inheritance, and they can get our assets in a matter of weeks instead of 6 to 12 months. So what do you think, honey? Should we do a traditional will and let the kids deal with the probate court proceeding on the back end, or do we want to make sure our kids avoid probate with a revocable living trust? All right, so those are the 9 things married couples should discuss prior to meeting with the estate planning attorney. As you can see, if you think about these things ahead of time, then you'll be better prepared to work with your attorney on making the best comprehensive estate plan that actually accomplishes the goals you have for yourself and your family. Hey, thanks so much for taking the time to watch this video. Don't forget to hit that subscribe button and the notifications bell next to it to be notified for new videos I post each week. And if you like it, then hey, thanks so much for taking the time to watch this video. Don't forget to hit that subscribe button and the notifications bell next to it to be notified for new videos I post each week. And if you like it, then please hit the like button. And if you know someone that needs to hear this, please share it with them. If you have a question or comment, please leave it. And if you ever have any questions about this topic or need to talk about your estate planning needs, you can set up a time to talk with me over the phone for free by going to myestatemeeting.com. That's myestatemeeting.com. Again, this is Elliott Feldman, estate planning attorney at the Elliott Feldman Law Group, where we create estate plans that actually work when your loved ones need it most. Take care.